Hello friends, welcome you all to Citizen Justice Forum video channel. If you are watching this video for the first time, subscribe and click the bell icon and select all so that whenever we are online, you get a notification and you don't miss any of our videos. आदाब नमस्कार दोस्तों, आप सभी का स्वागत है सिटीजन जस्टिस फोरम के इस वीडियो चैनल में। हमारा मिशन है टू एम्पावर सिटीजन्स। आज की जो एक टॉपिक है, नॉर्मली एफआईआर होने के बाद में जब पुलिस एक फाइनल रिपोर्ट बनाती है और कोर्ट में मैजिस्ट्रेट को भेजती है, तो उसके बाद में मैजिस्ट्रेट का क्या रोल है, जो सुप्रीम कोर्ट ने एक ऑर्डर के अंदर बहुत ही बेहतरीन तरीके से उसको समझाया है। अगर पुलिस का रिपोर्ट आने के बाद में मैजिस्ट्रेट के पास तीन ऑप्शन होते हैं। एक, तो जो वो फाइनल ऑर्डर है, फाइनल रिपोर्ट है, उसके ऊपर एक्ट करे। दूसरा, उसे रिजेक्ट करे। और तीसरा, अगर पुलिस रिपोर्ट के अंदर ऐसा कुछ लिखा हुआ है तो वो अपनी जो डिस्क्रिशनरी पावर है वो यूज करके सीआरपीसी 200 के अंदर फिर से वो इन्वेस्टिगेट करके वो केस को फिर वो कर सकते हैं। तो ये सुप्रीम कोर्ट के अंदर जब ये हुआ कि एक यूपी का मैटर था, जुनैद करके जो कंप्लेनेंट था, जिसके फैमिली को मारा गया था, पीटा गया था, 307 का केस हुआ था, उसने एफआईआर दर्ज की। पुलिस रिपोर्ट जब पेश हुआ तो इन्होंने वो प्रोटेस्ट पिटीशन फाइल की कि ये रिपोर्ट जो है पुलिस का वो सही नहीं है। मैजिस्ट्रेट ने उसके ऊपर एक्शन लिया और फिर से वो कंप्लेंट एडमिट करके उसके ऊपर इंक्वायरी चालू की। वो ऑर्डर को ऑपोजिट पार्टी ने हाई कोर्ट में चैलेंज किया और उसे क्वॉश किया। सेम अपील गई, क्रिमिनल अपील, सुप्रीम कोर्ट के अंदर, और सुप्रीम कोर्ट ने ये निष्कर्ष पे आए कि जो चीफ जुडिशियल मैजिस्ट्रेट थे उसने अपने पावर का सही इस्तेमाल किया और एफआईआर जो थी वो फिर से उसके ऊपर इन्वेस्टिगेशन करने में आए। तो ये जो ऑर्डर है ये आपको मेरे जो ब्लॉग है उसकी लिंक पे आपको मिल जाएगी, और उस ये लिंक जो है वो मैंने डिस्क्रिप्शन बॉक्स में डाला है। और इसका जो ऑर्डर है वो आर्टिकल के बॉटम में आपको मिल जाएगा, कि जो आप डाउनलोड कर सकते हो और पढ़ सकते हो और अपने केस के लिए यूज कर सकते हो। सुप्रीम कोर्ट जजमेंट ऑन डिस्क्रिशन ऑफ मैजिस्ट्रेट इन क्रिमिनल केसेस। In a recent judgment by Supreme Court of India in Criminal Appeal number 2628-2629 of 2023, the court reaffirmed the discretionary power of magistrate in criminal cases, specifically under Section 482 of the Code of Criminal Procedure 1973 CRPC. The case, Zunaid versus State of UP and others, revolved around the exercise of judicial discretion by the Chief Judicial Magistrate in a matter involving serious allegation, including those under Section 307 of IPC. Background of the case. The case originated from an FIR lodged by the appellant Junaid Khan on August 16, 2017. The FIR alleged that the respondents, armed with sharp edged weapons, had violently attacked him and his family due to an ongoing enmity. The attack resulted in severe injuries to his family members, necessitating their hospitalization. The FIR led to registration of a criminal case under various sections of IPC at PS Kotwali, Gorashinganj, Kanoj as the crime case number 907 of 2017. After a thorough investigation, the investigation officer submitted a final report in November 13, 2017. ये फाइनल रिपोर्ट जो था पुलिस का, वो कहीं ना कहीं जो आरोपी थे, जो अक्यूज थे, उसको बचाने की कोशिश में थे। डिस्प्यूट एंड प्रोसीडिंग्स, द डिससेटिस्फाइड विद द फाइनल रिपोर्ट, यानी जुनैद जो था वो पुलिस के ये फाइनल रिपोर्ट से खुश नहीं था। उसने एक अपना प्रोटेस्ट पिटीशन फाइल किया। The appellant filed a protest petition FR number 0611 of 18 before the CJM, seeking a fresh look at the matter. In a significant development, the CJM, through a detailed order dated November 15, 2018, rejected the final report and directed the registration of the protest petition as a complaint, case number 2783 of 2018. Subsequently, the CGM, in accordance with the section 200 and 202 of the CRPC, recorded the statements from the complainant and 8 other witnesses on January 11, 2022. He issued a summons to the respondent accused. The respondent accused, aggrieved by the issuance of the summons on January 11, 2022, filed an application under Section 482 CRPC number 14899 of 2022 before the High Court on July 20, 2022. They sought an amendment to the application requesting the setting aside of CGM's order dated November 15, 2018 and January 11, 2022. The High Court's intervention and error. The High Court, in its order, observed that the CGM's findings did not align with the requirements of the law as per the Section 190, subsection 1, subsection B of CRPC. It stated that the CGM had not sufficiently examined the papers accompanying by the police report and had prematurely treated the protest petition as a criminal case. The High Court also found CGM's conclusion to be insufficient to proceed with the protest petition as a complaint. The Supreme Court's clarification, यानी हाई कोर्ट ने जो सीजीएम का ऑर्डर था उसको सेट असाइड कर दिया. फिर जुनैद जो था वो सुप्रीम कोर्ट के अंदर उसने क्रिमिनल अपील फाइल की. The Supreme Court, in its judgment, emphatically clarified upon receiving a police report under Section 173 of CRPC, magistrate has 3 options. जैसे मैंने पहले बताया था कि मैजिस्ट्रेट के पास 3 ऑप्शन रहता है. एक, to drop the action if there is insufficient ground. To take cognizance based on the police report and issue process. Third, to take cognizance based on the original complaint and proceed under Section 200 of CRPC. Importantly, the court underscored that the magistrate discretion is not constrained even if the final police report is accepted and accused individuals are discharged. The magistrate retains the authority to take the cognizance of a complaint based on a similar allegation. This discretion allows the magistrate to independently assess the facts and determine whether to proceed. Erroneous High Court observation. The Supreme Court strongly criticized the High Court's observation, terming them as absolutely erroneous. It cited previous judgments, including Rakesh and another versus State of Uttar Pradesh and another, to establish that a magistrate can take cognizance of a complaint even if they had earlier declined to accept the police report. The court emphasized that the magistrate must apply their mind to the contents of the protest petition or complaint, but it is not bound by prior decisions. Conclusion. In the light of this consideration, the Supreme Court found that the CGM had exercised its discretion appropriately by rejecting the final report and accepting the protest petition and subsequently issuing a summons after recording statements. The High Court's interference with these orders was deemed improper. Consequently, the Supreme Court allowed the appeal squashed the High Court's orders and directed the concerned CGM to proceed with complaint case in accordance with the law, and respondent accused were given 2 weeks to respond to the summons and appear before the CGM. The judgment serves a significant reaffirmation of the discretionary power vested in the magistrate and their ability to exercise independent judgment. Even in the cases where a police report has been filed, it underscores the importance of the preserving judicial discretion in the interest of justice. If you want to read and download this order, you have to click here and you will get this order. Just wait for it. It takes the order of the Supreme Court. So whatever my blogs are there, you will have an article link and you will have a judgment link wherever it is possible. I hope you all like this video and you will subscribe to this channel and share it with your friends so that our family grows. See you again in the next video. Till then, take care of yourself and be safe. See you again.